Hello, everyone, and welcome to Adam and Reese's Privacy, Cybersecurity, and Data Management webinar series. I'm Sandra Claudio, a Business Development Manager in our Tampa office. I would like to welcome you to today's webinar, Is Your Data Secure? Protecting Confidential and Personal Information when Negotiating Third-Party Vendor Agreements. With me today are my colleagues David Katz, Karime Barry, and Caitlin Amick from our Atlanta office. David leads our privacy, cybersecurity, and data management team. Both Karime and Caitlin focus on privacy and cybersecurity issues and are accredited as certified information privacy professionals by the International Association of Privacy Professionals. Just a little housekeeping before we get started. We would love to hear from you today. If you have any questions during the presentation, please type them into the question box in your control panel. We will have time to address questions at the end. Also, we are recording the program today and we'll be sending you an email with a link so you can share the content with your colleagues. We will also send a copy of the slides to you. The program has been pre-approved for 1 hour of CLE credit in 5 states, and we will be submitting your attendance with state bars as indicated on your registration form. A certificate of attendance will also be provided to attendees. Now, I will turn it over to David Katz.
Thank you so much, Sandra, and good afternoon, and welcome to the webinar. And we're so appreciative that you would take the time today to listen to our presentation. And we have a presentation set up for you that we think is going to be useful and give you some practical and helpful tools to help you manage the risks related to engaging third-party vendors. So we're going to give you an overview today of the topics that we're going to be discussing. And the presentation is really broken into 2 parts. We're going to first talk about some of the diligence that you should be doing from a data security perspective. And these are tips and advice and guidance that you can use in your capacity as either in-house counsel or if you're on the technology team in your company. These are the things that we think are important for you to be asking any vendor that's going to be accessing your network, any vendor that's going to be processing data on your behalf. And so we've designed the presentation for the first part to cover what are the things that you should be asking when you begin to engage third party and offer up your information or your network to a third party. And then we're going to talk about what does the agreement need to look like when you're negotiating with those vendors, and how can you ensure that you are using best practices, that you're insisting on the most current language that's going to mitigate your risk in these particular areas. So really a 2-part presentation. First, we're going to talk about the kind of diligence that you need to be doing with examples of the physical protections that you should be considering or ensuring that your vendor is utilizing. If it's a software as a service, what kind of things should the vendor be able to provide to you to give you assurances that the software was developed properly? What are some risk-reducing policies and procedures that you need to be looking for the vendor to provide you to give you peace of mind when you begin to export your data or you allow them access into your system? And how are they managing their vulnerabilities and risk and regulatory compliance? And then finally, we're going to be talking about commercial agreements with third-party vendors, and we're going to share with you what are the key terms that you should be incorporating into these agreements, and how do those work in terms of the relationship, and where should you be pushing back, and how should you be negotiating hard to ensure that you're protected. So again, we're really thrilled that you would join us today and to take the time out of your schedule, and we're excited to provide some of this content for you on the call. And with that, I'll turn over to my colleague, Karime Barry. Karime?
Thanks, David. Good afternoon, ladies and gentlemen. I'm going to start with organizational security. Organizational security is the starting point to analyze the procedures that third-party vendors adopt to keep data secure. Third-party vendors are third-party organizations that routinely receive, send, transmit, store, controls, or processes data information, and their clients' information there is confidential or highly confidential. They can also be providers of technology or non-technology related service that require or include handling such information. Companies that use third-party vendors should make sure that the vendors have in place an effective organization security system which is critical for the safety of the company and its clients. The best way to check and evaluate the vendor's security system is to ask them what kind of security system they have put in place for themselves. If they don't have a system in place, we recommend that they adopt a formal policy to proactively analyze risk scenarios and mitigate risk events from unexpected loss or damage. In general, companies should organize their security system in different categories. For example, physical protections, software protections, and other policies. A physical protection system aims to protect information and assets from external risk events. And it is important to know if vendors keep the premises separated into different control areas, such as the server and computer room, operation areas, or loading delivery areas and others. Ask the vendor if they are monitoring devices used to track or to prevent unauthorized access to secure areas where information is being processed or stored. Do they require additional controls to the secured areas? For example, if they request written authorizations to have access to that area, or if a multi-factor authentication like an access badge and a PIN is required. Finally, policies and procedures should provide reasonable assurance that environmental controls exist to protect these facilities. For example, is the server supplied by an emergency power generator? And if the power generator service has been tested periodically. Regarding software protections, it is important to know if the third-party vendors maintain their data themselves or if they outsource this service and keep their data in a separate data center. If they keep their data in their cloud, they should indicate whether any anti-malware, antivirus, or similar endpoint protection software is provided or installed on their computers or systems. The vendor should also be asked to describe patching procedures for security and critical patches, along with antivirus and malware updates. The third-party vendors department responsible for security should be well established with clear descriptions of roles and responsibilities established for each member in the company. And the activities of the security organization should be independently monitored. You need to ask if they have a documented process to perform background checks on all outside subcontractors. And if they do, ask them to describe the process used to screen these individuals. If possible, also ask for a copy of the associated procedures. Finally, you should also ask if the third-party provider requires all employees and contractors to sign a no-disclosure or confidentiality agreement. Ask them to provide some evidence. Regarding logical access controls, next slide, any users of systems and assets should be granted access on a need-to-know basis, according to their job responsibilities. The access control policy should employ methods designed to physically and logically restrict access to equipment, ensure the identification and authentication of individuals who access computing resources, and also restrict an individual's access to information once that individual has accessed a system. Depending on the level of protection required, which is based on the asset classification, a combination of access control techniques may need to be employed. Does the vendor have a process for granting and documenting access, including access for subcontractors and remote access? The vendor has to make sure that there is a separation of duties between individuals who request access, authorize access, enable access, and verify access. You should ask the vendor to provide a copy of the procedures that they adopt. You should also be aware of the kind of procedure they use to manage inactive user accounts. Regarding the password management policy, the company has to adopt a password management policy, which should include and consider the password strength, password history, limited entry, retry attempts, inactivity logouts, and other passwords best practices. It is also important to have a two-factor authentication or a multi-factor authentication to verify remote users. Does your vendor have procedures to manage access for terminated transfereed employees and contractors? Also ask them to describe the process they use to terminate or transfer an employee or a contractor, including timeframes for access-related changes. What is the time frame between the request and systemic activation? They should describe the method used and whether accounts are disabled after a period of inactivity and if accounts are deleted after a period of inactivity. The bottom line is that administration processes and procedures should provide reasonable assurance that security administration is appropriately authorized, performed, documented, and reviewed. Regarding asset management, third-party revendors should also have an appropriate asset control policy structure, including ownership, management, licensing, and other controls that address information assets, software assets, and physical assets. You need to ask them if they have an asset management policy or program that has been approved by the management to maintain inventory of hardware, software, information assets, and physical assets. Have they classified information assets based on criticality or the sensitivity of information, for example, high, medium, or low? What kind of classification approach have they adopted? Do they periodically access unauthorized and unsupported hardware, software? If yes, they should describe the process in detail and share with you. With regard to personal asset policy, it is important to prohibit employees and contractors from performing business using personal devices. You should request a description of the policies in place for the use of personal devices if the third-party vendor would be using such devices in the course of their service provided to you or your client. Regarding equipment, does your vendor have a process to remove your or your client's information prior to decommissioning equipment that housed, stored, processed, control, or access those information? Do they perform the asset recertification periodically? They should describe the procedure when assets are misplaced or lost. The vendor should also describe the procedures they have adopted for decommissioning their equipment. How they manage it within the system can become a risk. Next slide, backup and offsite storage. Vendors must have a defined backup policy and associated procedures for backing data up in a scheduled and timely manner. Effective controls must be established to safeguard backed up data, both on and off-site. They must also ensure that your data is securely transferred or transported to and from backup locations. They should conduct periodic tests to ensure that data can be safely recovered from backup devices. Does the vendor have a documented process for how system, application, and data backups are performed? They should be able to describe their routine for backups and indicate how they ensure the backup process was successful. It is important to test the backups at least annually. Do they also routinely transfer backup files to an off-site location? If so, they should also describe the schedule and media rotation for the transfer and staging areas, including controls that exist to ensure backups are not rotated out until new backups are in place. They should indicate if backups are moved off-site in a timely manner. For example, a backup should not sit over a weekend. Does the vendor store backup media in our environmentally appropriate location on-site and off-site? Important to ask them to describe. Also, their backup media destruction processes and procedures should ensure the confidentiality of your company's information and your information when media no longer provides a useful purpose. Processes and procedures related to access for backup media should provide reasonable assurance that only authorized persons have access to clients' information. Does the third-party vendor secure the backups from unauthorized access and tampering by people that shouldn't have access to the information? If yes, ask them to describe how they are protected. Does they have access controls over data backups when stored off-site? Ultimately, processes and procedures related to off-site storage should provide reasonable assurance that the confidentiality, integrity, and availability of data information and your information is maintained. Does the vendor have a physical security plan for their off-site storage facility, including fire authority certification? Ask them to provide all the information regarding the off-site storage facility and indicate what access controls are implemented. Do they implement controls to safeguard information during transfer to and from their off-site location? And now I will turn it over to Caitlin Amick.
Thank you, Karime. One unfortunate truth about engaging third-party vendors and sharing your data with those vendors is that you're increasing your odds of a data breach because you're increasing the number of endpoints that are potentially vulnerable to attacks. And a recent report out, I believe this past month, said that 2 out of 3 data breaches can be traced back to vendor vulnerabilities. So it's particularly important to evaluate potential third-party providers and how they guard their communications and how they regulate the connectivity to their network, and also be thinking how you're allowing this third-party vendor to access your company's servers and systems, if at all. A good starting point would be to ask the vendor to see their network topology. This is where they would have mapped out where their endpoints are, where their potential vulnerabilities are. And the vendor might not be willing to share this with you, but it is a good starting place for the discussion. And it will give you a sense of how prepared the vendor is and how much thought they've given to protecting your data. And you, in addition to asking to see this network topology, you want to evaluate how the vendor is controlling the access to their networks. What kind of management approval is required for access behind certain firewalls? Are they doing regular audits of the access to their data? Are they monitoring and logging who has access to certain types of data? And are they disabling access if there's no longer a legitimate business need for that connectivity or that endpoint to exist? One of the basic things you should ask about and they should be willing to talk to you about in detail is their use of firewalls and how they are securing different aspects of their data network through the use of firewalls. And you also want to ask them about encryption. Encryption and firewalls are basically the bare minimum, and any third-party vendor should be comfortable giving you information about this. Data encryption is particularly important when we're talking about highly confidential information or information that's deemed personally identifiable information under state or federal and sometimes international laws and regulations. And so you want to evaluate how the vendor is encrypting their data, whether they're encrypting their data, what methods of encryption they're using. You want to ask to see a copy of their encryption policy. At the very least, they should have standards for the minimum levels of encryption strength that are required, and they should have a policy on how the encryption keys are maintained to ensure that the keys are kept secure. The one aspect of encrypting data that's important to consider is that if the data is encrypted, it can sometimes save a company from consumer notification requirements under the various state data breach notification laws. Some, not all states, will exempt consumer notification requirements if the affected data was encrypted. Sometimes this is true even if the key to the encryption is also compromised. At last check, both Georgia and Florida, for example, had exemptions to their data breach notification laws if the data involved was encrypted. So a little bit of due diligence on the front end can save the company a lot of headache on the back end just by ensuring that the vendor is using encryption methods properly. Another aspect to ask the vendor about, particularly in these COVID times where people are working remotely more, companies might be using internal IMing systems, internet messaging systems that they weren't using before. They might be using other collaboration software. I know Teams is getting really popular. Slack is sometimes used. You want to ask them how they are managing the use of these emails and IMing systems. Is data that contains confidential information, personally identifiable information, can you transmit that over these IMing systems? Are they only able to be sent through encrypted email? These are questions that you want to be asking. You also want to ask about if they are requiring two-factor authentication for accessing emails and IMing on their personal devices. And with more people working from home now, it's important to consider if the vendor allows for remote desktop use. This can make a company vulnerable to all different kinds of data attacks, particularly one that's called Katz attacks. This is particularly a problem for computers that are running older versions of Windows. So you want to ask the vendor if they allow for remote desktop access to your data, what type of system is used on their devices, and if at all possible, you want to push back and see if they can limit the use of remote access, remote desktoping. I think we can go ahead and jump to the next slide. And then I'll turn it over to David to discuss about the regulatory compliance aspect.
Great, thanks, Caitlin. So some of you may be asking, you know, in my individual case, how am I going to be able to look at an agreement and determine what steps need to be taken in terms of what's been explained to date? And the answer is, when these agreements come in, as you begin to identify the vendors for the various services that they're going to be providing the company, that's when the legal department really has to become educated and has to have a dialogue with either the internal security functions in the company or folks that are in the IT department to really understand what are the data elements that might be transferred, what systems are going to be potentially exposed or accessible. Is the company that's being engaged going to be providing services in their cloud? Are they going to be provided on the company's premises? Are they going to be managed services for the company's internal networks and technology? So there is a good amount of time that's spent in really understanding exactly what the relationship is, and then determining, based on that relationship, where the areas to focus the risk in terms of diligence. And obviously, regulatory compliance is a very large component of the risk here. And so depending on what industry you're in, if you're a bank, for example, and Graham Leach Bliley, the requirements that you have to ensure that data is being protected, that it's being protected in accordance with the requirements of the law, are things that you're going to, one, make sure that your vendor can do, but that you may specifically need to negotiate into the contract. And it may be the case that a comply with all laws provision that the vendor's providing in their form agreement may not be specific enough. It may need to be specifically tailored to the industry that you're in order to really get assurances and to make sure that if that contract is later audited by a regulator, you can point to that specific language and say, no, we are requiring these specific things in accordance with the law. And so, sometimes if things are happening fast or technology is being procured on a schedule that doesn't require as deep of a dive, those are areas where you can potentially get tripped up. One major development in cross-border international data transfers was the July 16th decision by the Courts of Justice for the European Union that essentially destroyed one of the major components of data transfer that companies were relying on. Approximately 5,300 companies in the US were relying on. And the major outcome of that opinion is that the standard contractual clauses, which was another form of data transfer mechanism, are the only remaining method contractually to transfer data internationally. And so if you have standard contractual clauses that are part of your existing vendor agreements, those need to be examined and potentially amended or altered depending on which jurisdiction that data is residing or being imported from. So, in terms of a contract perspective and a regulatory perspective, even an agreement that could have been in existence for some period of time could now be subject to additional review, regulatory scrutiny. And so if you're engaged in cross-border data transfers, it's really important that you start to consider whether this opinion has changed your practice and whether you're required. There's also been an explosion of state-specific statutes. And one example is the California Consumer Protection Act and the rights that that act gives consumers and the rights that are expected to flow down through your various vendor relationships to ensure that if a consumer is requesting information about how their data is being managed or wants to have access to their data, that contract that you've negotiated with your vendor enables you to be able to comply with that California law and be able to provide, in response to a consumer request, the information that consumer's asking for. And again, there are various state statutes, and you really have to understand the regulatory requirements of your own business to ensure that they're adequately reflected in the agreement. Opt-in and opt-out requirements, if there's any kind of texting going on with mobile phones or mobile applications or marketing agreements, those are ones that typically require a lot of scrutiny because there's a lot of data being transferred and a lot of engagement with consumers. And then privacy awareness training, really understanding if, on the other end of the relationship, if the individuals and the companies that are responsible for providing these services, are they providing any training to their employees about sensitive information, how to handle it specifically? So those are all things that really have to be part of that evaluation when you're out in the market and trying to find the right person to provide those services. And that's why it's so critical that the legal teams and the technology teams are talking well in advance before that contract comes in to really understand what should the expectation be. The other component of this is that you may get a 20-page agreement from a vendor and they say, well, this is our standard form and we really haven't changed this language for anybody else. One of the methods that I think has been pretty effective is to have an addendum that outlines all of these requirements that we're talking about and that incorporates some of the things that we've discussed here from both the diligence perspective, and we're going to talk more about this, but an addendum is an easy way to submit the document to be part of the contract and to have that vendor begin to review that addendum that should supersede the terms of their agreement and really almost use that as a diagnostic around how comfortable are they in agreeing to the provisions that are specific to security and privacy compliance. That often sometimes can give you a pretty big window into what kind of capabilities the vendor has and how much pushback you get could be a red flag right away. And maybe you don't have everything you want as part of the negotiation, but by the time the vendor has provided their comments or you've discussed the addendum that contains these provisions, you'll have a very good sense of the risk that's that could be in place for engaging with that vendor. So vulnerability monitoring, we've talked a little bit about that from a security perspective, but it's really important to understand if you're outsourcing data management to a third party, what capability do they have in monitoring their own systems? Because if they're vulnerable and they don't really have anything in place, they may not know if they've been the victim of a compromise. And an interesting fact about state data breach notification laws is that if you're the data owner, you're responsible for the notification, and oftentimes these third parties are not going to be the data owner. So even though they may have caused the incident, or it may have been their poor security that triggered a breach, you're still going to have all the obligations under state law for the notification part of this and the compliance part of this. And so that's another key component of why in those agreements, in your addendum or however you negotiate it, you have to have provisions around the costs associated with the notification, the investigation component of a notification. So that vulnerability piece and how they're managing the breach component is really, really important. Do they have intrusion detection capabilities? Are they monitoring their current state, and are they able to provide some assurances around how well they're doing that? So switching to software, if you're buying software as a service, one of the major components to software purchasing and the use of a third-party software is, was it developed in a secure process? And so, trying to get some visibility into the software development lifecycle, the systems development lifecycle, could also be a good indicator early on about how much time and effort they put in to creating a product that doesn't already contain some kind of vulnerabilities. And there are a lot of best practices that are associated with how software is developed. There are trainings and certifications that can be held by developers. There's a testing and maintenance component. And so while that may not be something that's in your agreement, because at that point you've already got the software, that needs to be something that's part of that diligence process in the diligence phase of your examination. So Karime is going to talk about subcontractors for a little bit, and then we'll come back with the rest of the presentation. Karime?
Thanks, David. Sometimes a third-party vendor will subcontract a portion of its services to another provider. If so, you must ensure that their subcontractors are adequately performing all the tasks assigned to them, and that all relevant language is included in any agreements between the third-party vendor and the subcontractor. Your vendor should also have a process to review all dependent security policies and procedures to ensure that appropriate security language is incorporated into all vendor agreement with subcontractors. Does the third-party vendor have procedures to assess the qualifications and performance of their subcontractors? If so, they should provide evidence confirming the qualifications of each subcontractor that has access to, sends, receives, or processes secure data on their behalf. Do their contracts with subcontractors incorporate appropriate elements of the information security policy requirements, including data protection, transmission controls, and document roles and responsibilities? They should send a detailed list of these elements. Does your service agreement include a clear specification of all relevant terms, conditions, responsibilities, and liabilities of both parties. Examples include compliance, audit reporting, on-site review, notification in case of change of risk, data ownership, insurance, liability, privacy, problem reporting and escalation procedures, ongoing monitoring, and applicable regulatory requirements. Do you have a process to review subcontractor performance relative to service level agreements to determine if contractual terms and conditions are being met and evaluate the need for revisions to service level agreements? Does your company have a process to perform periodic review of subcontractor user access rights to ensure appropriateness of access to your system? Finally, do you maintain appropriate documents and records regarding contract compliance, revision, and dispute resolution? Now we'll turn back to Caitlin Amick.
Thanks, Karime. Going back to what David mentioned regarding vulnerability monitoring and the importance of asking the vendor how they monitor for potential security incidents, it's also important to know what their plan is if and when a security incident occurs. There are many different types of incidents. When we say that, we mean security breaches, attempts to get access to the network or exfiltrate data, or if they identify vulnerabilities or security-related software malfunctions. So unfortunately, it's a question of when one of these may happen oftentimes and not if. And so you want to have a level of comfort around how they are going to respond to such an event. At the bare minimum, there needs to be a documented process in place that identifies how they classify and prioritize incidents and how they will report those up to you if it involves your data. And not only do you want to ask to see a copy of this process, but you want to ask about how their employees are trained regarding the plan, and you want to ask if the plan is ever tested. Oftentimes, it's seen as good practice to test incident response plans on an annual basis or whenever there's a large change in the individuals involved in the incident response team, because you don't want the first time that the vendor is dealing with a breach to be when it actually involves your data. I would much rather be in a planned testing of the incident response plan. And as David mentioned earlier, it's important to ask the vendor about the alert mechanisms and the vulnerability monitoring that they have in place to ensure that they are on top of it and able to let you know if and when your data is impacted by a security incident. David's now going to talk about the business continuity and disaster recovery plan, which is oftentimes encapsulated in an incident response plan.
Thanks, Caitlin. And just to add to that last slide, I mean, this is a good example of an area where, traditionally the vendor is not going to, in their agreement to you, list out all the things that they will do for you in the event of an information security incident, and the burden of really establishing that protocol really falls on you as the data owner. So being able to negotiate into the agreement the timeframes in which you're going to be notified, the process by which the vendor is going to have to engage in an investigation and provide you the details of that investigation, maybe develop a corrective action plan, provide a written report to you of a risk assessment and action plan that they're going to be taking, implementing a remediation plan to take all necessary and advisable corrective actions, cooperate fully with you, conduct a legal analysis to determine the compliance obligations that they may have. So all of that is stuff that you may be able to discuss up front, and that's really the place to have that conversation rather than than on the fly, because again, you'll be responsible for providing these types of details to the customers that have been affected by your vendor's breach. And that's very difficult to do kind of real time and in the moment. So business continuity and disaster recovery is a very important part of your agreement to nail down on the front end of negotiations, and making sure that your vendor has a documented recovery plan to identify the resources and actions that are going to be required to minimize losses if there's a disruption in the business unit or support group unit or the infrastructure component that's providing the services. So business continuity is to ensure that they can continue to operate, and disaster recovery is if everything is destroyed, and how will they end up being able to restore some of the data that's been destroyed. So how does that factor into your agreement or into where you should be negotiating into the contract? First, do they have that plan, and are they willing to provide it? And then, are they going to be maintaining it at all times? Are they going to be able to continually operate if there's a catastrophic event affecting their operations? And is it in accordance with what is traditionally accepted as business continuity, contingency, disaster recovery planning standards and procedures? So maybe if they're not willing to provide you the plan directly, because oftentimes there's very sensitive and confidential information in those plans, maybe they can furnish a summary upon execution of the agreement. And what are the notification procedures that are going to be incorporated if they do have an outage? And are they willing to provide, an audited report yearly that shows that they're testing the plan? And can they provide, documentation about their testing, if there are any deficiencies, and what it takes to correct those plans? So again, on the front end, having those assurances rather than, finding out everywhere that you stored your data is now a gigantic hole in the ground that's smoking, is a much better position to be in rather than trying to deal with it as the event is unfolding. So next we're going to talk about commercial agreements, and we're going to shift into, we've talked about this a little bit, but we're going to talk more specifically about some of the terms and some of the definitions and some of the other tips around negotiating and things that we've seen in practice. So we'll turn it back over to Caitlin.
Thanks. As David mentioned, it's oftentimes easiest to define the data security provisions in a data security addendum. And one benefit of having this addendum is that can be the one place where you define all the relevant terms. And it's particularly important to pay attention to the details here, as we all know, the devil is in the details on this. And so everything as basic as how you define personal information, confidential information, you can use the data security addendum to tailor this specific to regulations applicable to your industry. So if you're handling a lot of healthcare information, you can incorporate the definitions from the applicable regulations of personal identifiable information or protected healthcare information into the terms of personal information or confidential information as it relates to the data security addendum. There should also be careful attention paid to how information security incident is defined. It may seem obvious, but is a failed attempt to access a network considered a security incident that triggers various obligations? What if a hacker gains access to the third party's network, but they aren't able to actually exfiltrate any of that data? Is that considered an information security incident? Those questions can be addressed in defining that term. Another important term to define and pay attention to is how process or processing of personal information is defined. Generally here, the broader the better. Sometimes process or processing is defined narrowly, but It will give you broader protections if it includes things such as storing data, organizing data, maintaining or managing data, rather than just some technical processing of data. As David and Karime have mentioned, also the importance of defining who owns what data and clarifying whether the relationship is changing the data ownership is very important, because whoever is considered the data owner under the data breach notification laws has certain obligations. So that needs to be clearly defined in the agreement. And finally, going back to the use of remote software, this is your chance to define what applications and methods are allowable remote software use, and what remote software should and should not include when the vendor is handling your data. Karime is now going to talk about the compliance obligations and how you can integrate those into the data security addendum or the contract as a whole.
Thank you, Caitlin. Third-party vendors are obligated to comply with all applicable laws, ordinances, regulations, statutes, rules, and regulations to ensure that their performance will not result in breach of the agreement with your client or constitute any default under such agreement. So you need to make sure that there are no legal actions, suits, or other legal or administrative proceedings pending or threatened against vendor that could have a material adverse impact on your client or the activities involved in the agreement. Special attention should be given to privacy laws, including any international, federal, state, provincial, and local laws. Examples include the European GDPR, the US Fair Credit Reporting Act, and the Controlling the Assault of Non-Solicited Pornography and Marketing Act. That would be the main rules that should be visualized and should be considered when you're reviewing the contract with the subcontractors. Now I'll turn it over back to David.
Thanks, Karime. So this is really the fun part of the negotiation. Once you've gotten your addendum in a form that you feel really comfortable addresses all the regulatory components of the relationship and you feel good about security, now's the time to really discuss what happens if things go very wrong. And most of the time when you look at a vendor's agreement, software service provider, any kind of third-party service, they are going to do everything they can to limit their liability. And more often than not, the limitation of liability is centered around the cost for a year to 2 years of the agreement and not to exceed that cost. And really what you want to do is be able to begin to negotiate to be outside of that limitation of liability. And you have to be thoughtful about what is the ultimate yearly cost of the agreement, because that's the way obviously that the vendor is going to value how much more they're willing to put on the table for their own risk perspective and to be outside of that limitation. So some of it may be dependent on how much money is obviously being spent, but more often than not, depending on how bad that vendor wants the business, they're willing to make some exceptions to the limitation of liability. And what are those exceptions look like? So oftentimes you're ensuring that that indemnification that they're providing in the event that they do have an information security incident or for any other indemnification they provided you under the agreement is accepted from that limitation, meaning the limitation does not apply to their indemnification obligations. Liability arising from an information security incident, and we'll talk a little bit about how that's defined, but making sure that they haven't created a cap or a limit on liability related to an information security incident, because remember, you're on the hook for all those costs related to those notifications and potentially the investigation. And then typically we try to carve out an area where if they've breached a confidentiality or privacy provision of their agreement, that's also exempted. And then obviously gross negligence or willful misconduct. But oftentimes, even though the third parties want to include some kind of cap, they are open to the idea of establishing something outside of that cap and a basket of money to address liability related to these specific issues. And we've been successful negotiating that. And that event, that obviously is a number that everybody has to agree to and is comfortable with. But for companies that are used to serving regulated industries like on the banking side or other highly regulated healthcare side of the house, they're used to being asked about exceptions to their caps on liability. And oftentimes, they're prepared to put something on the table that might be in addition, to what they're limiting if you're asking for it. So a really important discussion to have. You want to have a right to audit under your agreement, and an information security audit, not a financial audit. You want to be able to ensure that they're willing to fully cooperate, that you have the right to initiate that if there's an information security incident or any kind of breach of the obligations under their agreement. And that if you're required to have authority audits, you have a regulator that comes in, you want to make sure that your vendor is in a position to be able to comply with a regulator because they're your third-party vendor. So negotiating that up front and making sure that it's included is pretty important. So you have that flexibility if you have questions or you really need that information. And obviously making sure they have cyber liability insurance coverage. And the amounts here vary. Most of the times we see up to 2 million, but it can be requesting up to 5 million or 10 million depending on the relationship. And so again, more kind of negotiation, discussion, ensuring that the coverage provides that their coverage provides coverage for denial or loss of service if they've been affected by malware or malicious code or unauthorized access, and that they'll provide proof that insurance is maintained for a period of 2 years after the agreement, and that they'll name you as an additional insured under the agreement, that they'll provide you proof of coverage all during the course of the term when requested. So these are sort of the key components to making sure that you're as protected as possible. And we think these are the three things that are really the main area of focus in limiting liability and reducing your risk. Again, there's some other things that you can do and work into your agreement that we think will protect you. Periodic control reports on the security of the processing, security of the data retention that's going on in the company. And depending on the vendor and the service they're providing, they may already be required to be generating what are called service organizational control reports, and they're Type 2, SOC 2, Type 2 reports, and they bear on the organization's ability to securely provide data that's available, confidential, and the controls related to the information that they're processing in their systems. And so being able to, under the terms of the agreement, get access or have those reports provided is something that could be pretty important to have. And making sure that if they do provide a report and it turns out that the controls aren't effective or deemed effective, or there's no compensating control in place where they've been dinged in a report, you want to make sure that they're required to remediate that and give you notice of the remediation. You can specify the requirements for business continuity, disaster recovery, and incident response plans, and delineate minimum information security safeguards. And those can be specifically listed, in that addendum in the agreement. So notice and liability requirements, you want to include a specific time frame. You want to have defense and indemnity that specifically covers the allocation and responsibility for incident expenses, including remediation and follow-up and monitoring and reporting. So all of that, like we said, can be negotiated beforehand and should be in those agreements. So this is our final slide, and then we're going to move to some of the questions that we're seeing in the queue. But there's a recent case that came out with a shareholder derivative suit, and it dealt with LabCorp's engagement of a third-party vendor that suffered 2 data breaches. And their vendors were, obviously handling and storing sensitive data on their behalf. And they were sued by their shareholders for failing to really adequately oversee their vendors, and then providing that PII with deficient security and breach protection. So this is becoming more of a and less of a nice to have and more of a real requirement to protect you from directors and officers from liability related to engaging these third parties without doing sufficient diligence around those parties. So we have a few minutes left in the presentation, and I want to have an opportunity to answer some of the questions that we've seen in the queue. I'll be pulling those up. One of the first questions is, what provisions do you recommend we put in the SaaS agreement to ensure that the client can get its data back, or better yet, keep running if the SaaS vendor goes out of business or its hosting vendor does? And that's a great question. And obviously, if the company goes out of business and the lights are off and no one's answering the calls, that can be a very difficult situation to try and enforce. But on the front end, obviously, in addition to the diligence around the economic health and viability of the vendor, oftentimes we look at termination provisions, termination or expiration assistance, and requiring the vendor to provide, continue without interruption after the term, to be able to deliver all of the confidential information, personal information, data, or any related documentation in a format that's requested by you as the client, and being available to answer any reasonable or pertinent questions on an as-needed basis, for a fixed period of time. So the agreement isn't just over and you're kind of scrambling if you have to migrate data or do anything like that. So that was, thank you for that question. This recording and slides will be available after the presentation for you to look at and for you to think about. One other question is, what is an information security incident? How is that defined in the addendum, or how should that be defined? And that definition really needs to be based on the definition that will trigger a notification obligation in the various states. And sometimes that's by access alone. Sometimes that's by access and acquisition, a combination of both those things. So your definition for information security incident should really include both of those components. The actual unauthorized acquisition of use and processing or loss of confidential personal information. And if you're feeling really aggressive in your agreement, you can base the information security incident definition on a suspicion or reasonable belief that that's occurred. And then obviously if there's been evidence of unauthorized use. So there's a question about which states were confirmed in for CLE, and I think we can provide that information on the website or at a later point. And so those are all the questions it looks like are in the queue. And obviously, if you have questions after this, or you look at the slides and listen to the presentation, we're always happy to hear back, get your feedback and spend some time thinking about your question, and helping you kind of think about these issues in more detail and working in any way we can to assist. So I'd like to thank Karime and Caitlin for a great presentation and providing some great information today. And we'd like to thank all of you for listening and participating and being with us for a little bit of the time today. So thank you for attending, and Sandra, I'll turn it back over to you.
Thanks, David, Karime, and Caitlin. Again, we just want to reiterate and thank everyone for allowing us to present this program to you today and for spending this hour of your day with us. As a reminder, we recorded the session today and we'll be sending you a link along with a copy of the slides and certificate of attendance for CLE credit. In closing, we would like to mention that our firm has produced numerous privacy and cybersecurity related resources and information on our firm's website, adamsandreese.com. Updates can also be found by following the firm's pages on LinkedIn, Twitter, Facebook, and YouTube. We will continue to share the latest developments and provide insights on privacy and cybersecurity. Thanks again, and have a nice afternoon.